Why it has come? Why it has come?
The direction to have affidavit. And the affidavit matter was not listed.
That hearing was concluded on 19th of November.
That we noticed that was for orders to be kept. But I find there are many things which have to be looked into. So can you just recapitulate what has been argued?
For the petitioner, in two cases,
Because I find from a written notes of
Both side.
very difficult to comprehend. With all humility and the respect to my command. Both. Can you recapitulate? Who is for the petitioner?
I am for the petitioner.
Yes, can you?
Three cases, in three cases, I am for the petitioner.
Please, can you?
One case, he is the petitioner.
Can you recapitulate the issue? Could it?
More time he needs,
Because this is for orders, so that's why I just wanted. Whether I have gone through those
to come in the
and notes of arguments are so. I do not want to make comment. So when you write a notes of argument, then you have to pinpoint not only the crux of the facts, but also the point which you wanted to argue. I can give the file to any of you, you just go through it and tell me that whether anybody can make out a case, what you have, what you want to argue.
So, to be mentioned here last week, so that it to be mentioned here, will apprise your lordship so that
Even I am unable to find out what is the issue there. Mr. Das also. Not taking out something from the pleading and then say, no, sir. Written notes of arguments are not meant for that. You cut and paste theory and then do it.
also may call it to be
You
mentioned.
have not formulated even a point for argument. Writing a bad judgment is not appreciated. If bench gets strength when the bar is strong. Well,
You must fix a date. 1 week after, you will also hit it. Second week of March. Second week of March. Ten.
yes.
Good.
What is the Thursday in this class?
Good.
Tuesday. It is Tuesday. It may not be
So here the conducting layer now appointed as a AG. Conducting layer, Mr. Rai, appointed as AG in this
SG, he has been appointed since long. This matter is filed in 2024.
my letter of and in time the petitioner is residing in Chennai. I have already informed him.
Just 3 hours application is
Huh?
the pendency of all.
What remains in the petition? It has become infructuous in that sense.
Before lordship, only
Sir,
one adjournment.
after 2004 Act,
Before
sir, 2000 rules being substituted or
my
repealed, and in its place 2016 rules have
15
come.
15 has
16.
auction. 16 is a concession.
Concession, that is OMMC.
Auction rules have also come in
That
2015.
is central.
So on.
then MMDR Act comes 2015, but Odisha minor mineral concession rule, lordship is 2016.
I
But
understand.
I filed that case.
So
before 15.
the rule will override the
I
substantive law.
filed that case because this is the only
Sorry.
the government. My lord, only one argument I will
No,
satisfy
sir.
lordship.
2024, then nothing has happened till then. Your application has been rejected long back. Now what is there? 2023 it is rejected.
The government officials, they are not here my matter, and I have
They have heard and you asked
the
the
first applicant. I am-
to give you a opportunity to complete the proceedings. That was done. What more?
I am the first applicant, but they, your lordship kindly see annexure 5 that they are not mentioned particularly. The first applicant, I myself the first applicant, but the later applicants,
1819, correct.
and I have also filed that before 16.
Very clear reasons has been.
Have been decided. What more?
I have filed the application before 16. It's a retrospective.
Oh, whatever.
So how the latches of the government authority, why the petitioner will suffer? They have intentionally, deliberately, they have not heard my case, and I have come to this honorable court, and this honorable court direct the officials. Then they will have only one adjournment. Only my humble prayer. I will satisfy, and our document will serve.
Keep this matter tomorrow. Let you argue. First matter. And adjournment is sought on behalf of the erstwhile council appearance.
Item number 2.
Lordship, I seek a short adjournment in this matter, Your Lordship. The learned counsel on record is unwell today. So any date next week, Your Lordship, if Lordship can accommodate.
Madam, these are the matters of 2024. If we are listing those matters, because this has not been listed, every time the adjournment is sought.
It is regarding refund.
Yes, my lord.
It's a royalty.
He was unsuccessful.
No, my lord, here he is asking for refund because we did not issue the receipts, my lords. That is the ground which
What?
receipts of royalty which was supposed to be given. That is the ground which is mentioned in the writ petition.
He has applied for a return of the royalty because he has not been permitted.
My lords, here he was.
So
Or deposit receipts he did
Yes, my
not
lord.
furnish, original receipts.
Only original receipt, my lord. I have
You
sought
do not have the accounting system in your department, whether somebody has deposited the money under what head.
Well, it's now there is a portal, my lords. Everything is done in the portal. That is what I had sought for instructions, my lords.
What instruction? This matter is 2024. You have been served with a copy in 2024. Still instruction is awaiting.
My lords, only one.
Something is very strange. I cannot. I have been since
These are the
last
receipts?
11 months. I have been harping on that. I am unsuccessful. My incompetence,
Now,
because
this-
it has gone to a deaf ears all the time.
Now, are you disputing this receipt book, your money receipts? Are you disputing this 1,78,000 and 11,02,000 which are paid
No, my lords, that is not
page
disputed.
22, 23,
Payment of
24?
royalty is not disputed, my lord.
Huh.
Only claim here is made by the petitioner that we did not give the money received with respect to the royalty, my lords. Whether that is a mandatory requirement, and if it's done in the portal, my lords, then everything is communicated to the petitioner automatically, my lords.
No, what is done these receipts,
That
money receipts?
money received which were paid, my lords, when
There it is written additional charge, SR, DR, then EMF, DMF, TCS.
my lords, para 4.7, page number 6 is the main ground, my lords.
Hmm.
Delay of the, that is the.
You have not generated the receipts and given it.
Well, I have sought for instruction, my lord, because if it's done in the portal, my lord, then everything must have been communicated, my lord. Oh, because I could not, my lord, if one opportunity will be granted, my lord, I will get the instruction, my lord. Because if it's done in through the portal, everything is communicated is in the fair, transparent manner, my lord. If
He has deposited. You have not issued a receipt,
that is the ground, my lord, my lord, only, my lord.
and you and that is what he says, that he must have transferred it in your account.
Yes, my lord.
So
My lord, I haven't been able to obtain instruction, my lord, because my only.
why?
It's,
This was filed on 22nd of July 2024.
yes, my lord.
The
Page,
copy must have been served immediately prior to this. No instruction.
page 26, NEFT.
Yes,
Are
my
you
lord.
disputing this?
My lord, I'm not disputing, my lord. The only thing is that it's done in the portal, then
You
you
have to
must have.
generate the receipt and acknowledgement
My lord,
receipt, that's all.
only predicament because my lord.
Total deposit made,
We are taking a very, very strong view in this, that everything it has been done, still taking an advantage of these situations, you are really, and the exemplary compensation.
My lord, if it's otherwise, my lord, if he must have known, then there would be a problem because my lord.
What problem?
My lord, if it's done in the portal, my lord, only submission, my lord. If it's done in the portal.
If the money has gone to your credit,
Yes, my lord.
what more? Will you not generate the receipt?
My lord, to the government, whether the government is correct or not.
Government is correct, and you are taking more than nearly 2 years to verify the governments to be correct or not.
It's only one class, my lord.
What one chance?
I've not been able to obtain instructions in this.
Why? You were sleeping in a slumber?
This was marked to me on recently. my lord.
That is the whole problem which I am saying. That's why I say my instructions, I will be now very strict in this. First timer theory or a notion, I am deadly against it. I think this will be one of the case example. Let me dictate the order and let me be very critical on the entire functioning which is happening in this court.
Yes, I request my lords, my lords.
2024 writ petition. First unfortunate thing is that it has not been listed. Second unfortunate is that till date you have not received the instruction. And the brief is never marked unless it is listed. It is what the modus operandi in the office. That unless the matter is listed, no brief will be allotted to any person. Why not? Immediately when you receive the copy, why you will not allot it?
You are not having any further instructions?
Lordship, I'm not the counsel on record in this matter. If the matter can be listed tomorrow, even that would be, Lordship, I'll be grateful. The counsel on
You have seen the adjournment is sought. Even you have come.
You get the instructions today.
I've already asked for my lords.
No. Today you ensure the instruction. That's all. That is the only thing.
Which I'm trying, my lords.
Paying of refund of the excess amount charged on additional charges from the including the royalty. That is the DMF and EMS.
Additional charge.
When you have deposited.
I think additional charge is already covered by some judgment.
DMF charges.
That is under the rules itself.
No, additional charge we have interpreted not to.
Further additional.
That
That is what is further. This is the additional charge.
DMF will be charged from the royalty.
This is also somewhere decided, obviously.
Where is the acknowledgement of when that it is paid in excess?
Well, that is 26, madam.
Page
26. And it's actually page 26. Below table, madam.
yes.
The DMF at the rate of 10% of royalty and additional charges.
So
And EMF also 5% of royalty and additional charges.
yes.
But there is a charges only on the royalty money only, not on the additional charges.
No, there is already a 2016 rules.
Yes, 2016 madam.
Yes, there is a provision for an additional charges to be levied.
That's 26.
Rule 26. You have highlighted
That
that.
is EMF. Rule 26 is 6, sub-rule 6.
Sub-rule 6.
Yes, madam. The SSL pay.
No, if you come to rule 27. No, this is a query lease or what?
Madam, send query, madam.
Send query.
Send query.
Then you come under chapter 4. Rule 27. Not under chapter 3.
That is the problem. The charges.
Chapter 3 is relating to a specified minor mineral. It is not related to sand query.
But 27.
The chapter 4 grant is a grant of query leases. You are under the query leases.
Yes, madam.
Please come to sub-rule 7. The selected bidder shall be required to convey his acceptance on the terms and conditions and to deposit an amount which will be calculated in such a way that it shall be equivalent to 1/4 of the total amount of royalty and additional charges.
But that is the problem. Royalty and additional charges. What the
True.
DMF will be charged?
And the amount of contribution toward the DMF. So you are talking about there cannot be further additional charges on EMF.
EMF, madam.
But it is 10% of the royalty and that is under DMF and EMF is also a royalty.
Only on the royalty, madam. That the DMF and EMF will be charged only on the royalty.
True. So what they have done?
The rule, district mineral fund, the rules 2015, my lord, it says. District mineral on the rules 2015, that is rule 9.
Where it is.
Rule 9 2B.
What is that?
It's
कितना number volume कौन?
there's a volume 4. Then
Four.
that Pujha will
Get that one.
Yes.
it's page 393.
What? District Mineral Fund, the Mineral Foundation rules?
Yes, sir.
Yes, DMF?
Nine, yes, sir.
Yes?
This is DMF.
Huh?
This is DMF.
Correct.
The rule 9 2B. The amount payable by lessee of the mineral to the trust. The two, all holders of the minor minerals leases sell in addition to the royalty paid to the respective trust amount equivalent to.
So according to you that yes, DMF will be on a percentage basis of the royalty,
On the royalty.
but there cannot be an additional charges imposed thereupon.
Yes, ma'am.
This is what your case is.
Yes, ma'am.
How can you add the additional charges on the income tax as well?
It's here, what has been done is, my lords,
I am asking you, so how the madam it can be done?
it's here the ground of challenge is that additional DMF cannot be charged on the additional charge, my lords. Here since 2021, the demand notices were made and the petitioner had made payments, my lords. And
what?
now in 2000,
Can you, now I am Article 246 and 246A. Can you charge anything beyond the conceivable legislative powers conferred upon you? Even a person has paid, that does not mean it's a gratuitous payment. You can't accept it. You cannot charge anything beyond this statutory provision. If somebody has paid under the mistaken advice, whatever, or under the mistaken demand, can he not raise subsequently?
these demands were never challenged by the petitioner, my lords.
No, you
It's
can't
not necessary. He says, I'm not challenging. I'm saying that you are charging an excess amount.
Page 43 is very clear. Table. This Tahsildar has made it. Yes. DMA at the rate of 10% of royalty plus additional
46.
46.
No, I'm 26.
Plus 43.
I'm also
Huh.
talking about
Acha, 26
also.
different times.
Different year. The second year, that is
Oh, acha.
26.
Different years he has.
Yes, sir.
Oh, same type of calculation.
Same for
Yes, take.
from
And
2020.
How can it be justified?
when the same has been gone to the government with a direct minor, that's 59 minor. They only charges on royalty, not on additional charges.
Oh, after the shift,
Yes, ma'am.
after the amendment,
For the authority shift to minor.
second amendment,
Yes.
2022 or
Yes.
23.
That's 59.
Yes. Mining officer has charged
DMF.
correctly.
Yes, ma'am. DMF at the rate of 10% of royalty.
Huh.
Not
But how
excess
can,
charges.
I understand. How can there be? Oh,
No,
the
that was
income tax
considered.
is on both the additional charges. Okay, that is correct. That is correct. How can you do it, madam?
No, this is correct. What he is
No,
doing
I
there?
was
acha,
thinking of income tax at the rate of 10% of royalty.
No, here the DMF is 10%. What is
I was under the impression that
TCS,
that the income tax, the additional charges is also. Let me do it again. I wasn't, no, it is both the component, then 2% of the both.
Statute, it should be on royalty, my lords.
So,
Yes, my lords.
But
But
what he is projecting is when you made some amendment in statute and that's rules, and now the matters have been dealt with by mining officer, he has correctly done for subsequent periods. For earlier periods, he could come to know from this that
my lords, only thing.
the calculation and collection was without authority and law.
Yes, my lords, the 21 from 2021 onwards, why Tehsildar had imposed such condition, my lords, and it was never disputed at that point of time, my lords. To that effect, it
no
may be.
dispute. Where is the dispute? Tell me. The law is very clear on this. You can only charge under Rule 27, Sub-Rule 7. Not beyond that.
And DMF is only payable on the royalty and EMF under 49.
So DMF is also given that it has to be paid on the royalty.
Yes, sir.
It cannot go. That is, I think under the MMDR Act itself.
Well, that will be governed by the rules of 2015, DMF rules of 2015, which.
So it talks about simply royalty.
Yes.
So how can you charge on the additional charges as well? It's a calculation mistake. How much is the amount refundable to you?
That is the paragraph 8.
Have you made a calculation?
Yes, no. Paragraph 8, no. The 47,71,262.
Yes. Payback.
If I may get one opportunity, my lords.
What opportunity?
It's here application.
It is one of the, I would say, the classic example of open and shut case.
My lords, as per rule 55, if there is a mistake, my lords, collector has the power to rectify, my lords.
Yes.
No, you have power, but you have not exercised.
That application,
In spite of it,
application was never made by the petitioner.
why so? Can't you rectify yourself? Every citizen has to run after you.
It is neither a clerical nor a mathematical mistake, nor it can be termed as an error arising from an accidental slip or omission. It is a conscious decision taken by an authority, dehoves the law. What Rule 55 is akin to Section 152 of the Code of Civil Procedure.
In Vivid Marble, 2006, Honorable Supreme Court has said the statutory authorities can rectify and apply appropriately. If it is grant of benefit to assessee or the citizen.
If only, my lords, if I can take instruction whether this calculation is correct or not, my lords.
No, we are directing you to make a calculation.
Apparently on the face of the table itself,
Yes, my lord.
Where is yes. What is the prayer?
page 7. The restriction stating that the collection of DMF and EMF over additional charges is illegal.
Yes.
And accordingly, direct the opposite parties to refund the amount of 10% DMF and 5% EMF over additional charges levied from the petitioner.
The seminal point involved
The next one is the date of the page 62. The date is
Next one, which one?
Same matter, same matter.
Same?
Item 4.
Let us see. What is this?
The date only is the 28 to 24 of the letter of the director. Last page.
Two river beds, numbers.
Where it is?
Yeah, they won the 18 March. And this
For
one
the same,
is
For different party.
for different party.
And two different river beds.
Same order.
only the date is
The same Tahsil.
10 decimal.
Item 5.
May I please, my lords? Am I audible, my lords? May I please? My lords, the petitioner here is one of the largest purchasers of coal from MCL, the respondent herein. The respondent, my lords, when I purchase coal, let me contextualize, my lords. When I purchase coal, I can either take it on the rail transport or a road transport. In a rail transport, I am not asked to pay any premium.
Oh, this has been done by the Mahanadi Coalfield.
Yes, my lords.
So they have to be noticed. Are you appearing?
Bills, I'm
Oh, notice returnable after 2 weeks. Put in the requisites by day after tomorrow. Yes, come.
Item number 6.
Dates of those.
Maybe.
6 minutes, my lunch. Senior Mr. Ashok Panigar is appearing to Gotchal.
Oh,
Mr. Panigar is
Item 6. Please, your lordships.
just 1 minute. What is?
Again.
But I wanted to make a request.
Yes, what is the point? Yes,
My lords, I was wanting to make a request, my lords. I am a little. Can I request for a physical hearing of this matter on the coming Monday, my lords?
why not? Why did you come today? 3 days time was given to you. This matter was
My
listed
lord,
Friday in the list.
I was informed on Saturday. I had some difficulty, my lords. So I'm making a request if I could just, my lord. Any date, if I
I do
can
not
request for
know. Now it is the opportunity to address on a virtual mode. There is
I know that, but I'm a little.
What is the difficulty? Virtual mode.
No, I can address virtually also. I have no issues. Today I'm amid some difficulty, my lords. So I was just requesting that if I could just get any other date, I can address virtually, physical. That shouldn't be an issue.
So in the morning we have taken the government advocate to task.
Yes, my lords. I was told that some item to
So-
your lordships. was-
And these are the matters of 2025, long back, it has not been listed.
Yes. In
So,
fact, I was to come physically and do this before my lords. But my lords, I can do this virtually also. Could I just request for next Monday, my lords, if that is not inconvenient to my lords?
No, the Monday is not a day for this mining minerals matter. We have identified a day that is on Tuesday only. And we do not take up those matters.
All right, my lords, then can I request for next Tuesday, my lords? I was told Monday is what my lords is listing. Can I
No
request for
instruction.
next?
Malats, here, Malats, I had a point on entertainability, my lords, because this is an order passed by Director of Mines and appeal is provided the state government against this order, my lords. And here, because it's a detailed,
This is the earlier, I think they were permitted to go for a review.
my lords.
They went for a review. Now they are challenging both the present and the review order.
Yes, my lords, from Supreme Court, they were directed to,
No, that is their appeal.
Yes,
And
ma'am.
without insisting for a limitation.
yes, my lords.
That was done.
Yes, ma'am.
Then they approached this court challenging that.
Yes, ma'am.
They were reverted back to exhaust the remedy of review.
Yes, ma'am.
Now they have gone for a review. Now after the review, they have again come
Yes.
against both the orders. So again relegating them to state government.
Because as per the,
What the state government?
my lords,
Is there any opportunity of hearing here, given who will hear the appeal, the state government?
the secretary, my lords, will.
Come on next Tuesday.
All right, deeply obliged. Sorry, my lords, for the inconvenience.
Yes.
Before my lords, petitioner staff, my lords, this is a single bench assignment matter, my lords. Yes, my lords. OPDR Act proceeding under OPDR Act is under challenge, my lords, Annexure 1. That's the, my lords. That is under, that is the only, that is the only order which is challenged. my lords.
Consequential order without challenging the present order.
এটা হলো মেন প্রভিশন
If you challenge the constitutional order without challenging the present order, then you
সেই
maintain
পোর্শনটাকে ছাড়িয়ে
That order, my lord, against that order,
এইটা
the
ছাড়িয়ে দিলে
rejection of my renewal application and present petition of filed writ application. This honorable court directed me to file revision before the revisional authority, and that revision is pending before the revisional authority. The state government has appealed and took several adjournments in the revision case. I have also filed in the common cause case before the honorable apex court, and that is also pending because not then.
No, I am not very legal point. Is it true that you are challenging a consequential order
Yes,
without challenging the main order?
main order that is, yeah, I have yes,
Main order challenge
and that has been pending before the revisional authority.
it was pending.
Yes.
Is it pending still?
Yes, ma'am.
During the course of pendency, this
The
order
order
has
has-
come to be passed.
Yes.
Which is consequent upon the main order. Is this?
No stay.
What is this? That you go there actually.
Division of authority, your worship में
There is one judgment of the Supreme Court on this ground. Maintainability. Yes, that cannot be done. It does not fly. Sorry, sir. You can't.
you might not, your worship may call it next week. I will examine the matter. Next week.
Without challenging the parents.
I have challenged the parent order before this.
For the regional authority.
No, madam, this honorable court delegated me to the divisional authority.
Then the bottom line of the entire episode is that you have challenged the parent order before the regional authority.
Yes, sir.
If this is a consequential order, then will you not go to the regional authority? How can you come to us?
May not divisional authority that
They have not decided the matter as yet. Then in that event, can you bypass and come straight away? I'm just asking this question. Please try to understand. This apex court has said that the consequential order, if you challenge alone, not permissible. Unless you challenge the parent order also. It cannot be done. This is not permissible.
I will examine the matter.
What example?
I will capture your worship made costly.
Consequential order is straight away. There is a consequential order.
Matter is also pending before the Honorable Apex Court. On 10th, it was listed before the Honorable Court. Before the Honorable Apex Court, the matter has been adjourned.
Bring 2010 volume 1 SSC page 417. Paragraph 20. 28, 29 and 30. Not be helped out.
I will pursue it.
Reach paragraph 20. You have to dismiss it. Focus on. Paragraph 28 is relatively. Para 28, sir. Left hand side, top page. So challenging the main order.
I will withdraw the writ. I will withdraw the writ petition and pursue the remedy.
What does to decide? Yes. Again,
Memo. Item number 9.
Relative annexure rate. This is my second journey to a This is my second journey to a lordship's court.
I think the first journey must be very pleasant.
Yes. That is annexure 17.
Yes.
I am challenging annexure 18. 18. 1-8. Yes.
Page number.
I know. Page number. Yes. That is page 90. 90.
Yes.
My lord, the Kori lease was granted in 2020. It was meant for 5 years, but I could not operate because of the non-grant of the CTE, CTO, and all.
You want an extension of time.
My lord, they have the DFO has stated that it is coming within the forest area. Although earlier the DFO was of the view that it is not coming, for which the Kori lease was granted in my favor. And for this purpose, I am deprived of operating the wind query for about 28 months.
Now, what is this? So 28 months you were permitted to operate.
No, I was not permitted to operate 28 months.
Then for the rest of the time, how you operated?
I operated by manually. I operated manually.
So it says it comes within the forest area. That's what.
But earlier the forest DFO has granted the permission.
So they have taken a different view
Yes.
during the pendency of your lease.
Yes. Yes.
Of your permit.
Yes. During pendency of, because 2025 till 2025.
When they have taken a decision that it comes within the forest area.
Your lordship may kindly turn to page 93. Page 93, 4. Order clause 4. Which is contrary to the OSAC, the
This is a reserve forest.
no, it is nearer to reserve forest, but the area is not
inside the boundary.
No, it is not coming with inside the boundary because it is Patita Pisam of land for which Tahsildar was empowered at that point of time for grant of Kori lease.
Madam, paragraph 4 and 5 shows
Yes.
that it comes within.
Yes, according to him, but your lordship may read it along with Annex 15, page 81.
Yes.
Page 81.
Yes.
Yes. This is the mining officer has wrote to the DFO. Minor first para, after 4 to 5 lines, to ascertain the truth, I, along with Risa team, BBSR, range officer, so and so, to the spot on 28.
was sought for.
That he does not have because the boundary is within the boundary of the forest is within the realm of that particular DFO. So he says that though he has gone there, on physical verification, it appears that it is far distant place. But again, you please clarify. That's the second paragraph. It says clarify whether it comes.
Yes.
Because he has complied all the terms and conditions for a quarry permit. So, but ultimately the DFO must have.
My lord, that DFO has not, you lost him, kindly turn to that page once again. Page 93.
Yes.
Item 4, the field enquiry report of forest range officer, so and so, submitted by memo number so and so, report dated so and so.
There is a joint field inquiry.
My lord, joint inquiry, it is also the mining officer has
That they have gone.
Yes.
Submitted and concluded.
Yes.
That plot number 158A.
Yes.
At the village such and such.
Yes.
Is coming inside the boundary of Dindanai South PRL of such and such village.
But my lord, the ROR source, your lordship may kindly turn to page.
ROR, talking about that, ROR may be the entry has a presumptive value of its correctness, but it does not mean that it is sacrosanct.
My lord, that is true.
So if on the field inquiry, if the concerned officer has found during that it comes, then there is
my lord, question is when in 2020 it was granted in my favor. At that point of time, Forest Department has also given consent. Soon after which Kori lease was granted to me, and it was the agreement was entered into.
Madam, only thing is that whatever the amount which you have paid for this 26 or 28 months, you have to return it. They will return it. That is what I have taken a view on Rule 64.
My lord, may I submit one thing? Your lordship may kindly go to your lordship's order. Annexure 17. Yes. Your lordship has vividly stated everything in the order. And ultimately, yes, your lordship was and thereafter paragraph
said that the opinion shall be
No, to consider the grievance. It has not said anything. It
Yes.
simply say that consider the grievance or that grant. So now they have considered.
my lord, they had only therefore is standing on the way. Although OSA team, my lord, OSA team,
It was a joint inspection as well,
my lord, may
and it is not a.
my lord, may I joint inspection, I will produce another report which has been made by the OSA. That is the space. OSAC is the Orissa Space Application Center. Odisha Space
What they will
Application.
do, space,
Because they have from the
the satellite view.
yes, satellite view.
Satellite view. is
They have taken.
Absolutely correct with precision, with all the degrees with precision.
My lord, then what? My lord, then question is what?
There is a possibility of change.
And the range officer, forest range officer was very much present earlier also.
But once it comes within the reserve forest area,
My lord, it is not.
maybe under the mistaken advice they have done,
My lord,
but once it comes, then
my lord, may I
it's
suggest?
it's a joint field inquiry.
It's a joint-
There was a survey relay of the entire plot. If the survey relay shows that it comes, then
My lord, your lordship had the consent to operate and everything, all other things.
what they have said, your mining officer also said that you have complied all the terms and conditions.
Yes.
But whether it comes within the forest area or not is the issue. Now they found it comes, we have done it, so you are not at fault. But still.
My lord, one more thing.
We should.
My lord, one more thing. My lord, the range officer is the forest person. He belongs to the forest department. The range officer was present at the earliest time when it was inquired into by all the officers. That report I will produce, keeping that in view, and also right now the order passed by the DFO. The lordship may kindly consider both of it. Otherwise, my lord, I will be nowhere.
You are entitled to refund of the money. You have to refund the money.
But
If that was your mistake, you ought not to have granted this query permit if the plot or the things comes within the
forest area.
forest. You could not. And you have collected whatever the dead rate, whatever the royalty, whatever is there. But if they could not operate because of this order, then nothing is happening.
Initially, they operate malus thereafter, whether they are deposited or not, malus, I don't know. Yes, I have. The grievance of the petitioner was also considered by the mining officer. They have passed an order on 2nd January 2026 because the direction was given to DFO as well as the mining officer. My lord, I have also filed a contempt because your lordship was pleased directly to do it within a week. He is sitting contempt against the mining officer.
What? Against which order?
Against your lordship's order? Your lordship may kindly.
Our order was not.
Yes.
Our order was simply consideration.
Your lordship may kindly do it.
Time was over.
over, sir. Time was over, sir.
My lord, your lordship may kindly
They have done the needful.
it is expected that the OP number 3 and 4 and 5 shall act in tandem and do the needful as directed above within a week.
So we have said that in view, we have recorded the submission and says that in view of the aforesaid, this court directs the mining officer competent authority to consider the grievance of the petitioner for grant of permission to operate the quarry machine. And the divisional forest officer is also directed to consider the grant of clearance so as to enable it to be accorded with permission for blasting by the collector such as it is expected that opposite party 3 and 4 files are acting tandem and do the needful as directed within a week from this. That does not mean that they have to grant you a permit.
No, no,
Or
I am not
decision.
there. I am not there. My lord,
If
because
they have
No, because-
crossed the limit which is set for their.
DFO has done, DFO has done his duty, but so far as mining officer is concerned, he has not taken up the issue for about 2 months. Your lordship, for which I have filed the contempt against the mining officer, not against the DFO. And I am challenging the order of the DFO right now before your lordship. Because for no fault of mine, why should I be put into suffering?
Where is the order of the DFO?
DFO annexure 18.
Second one is there.
Annexure 18.
Yes. I think it's made the order of
Because why should I suffer? But for their latches, why should I suffer? Because I have paid. My lord, that may be reflected. That may I will approach the authority for getting back my dues. Whatever I have paid.
It goes without
The competent authority had already passed an order
What?
rejecting the prayer of refund, my lords.
When rejecting it, they are not for grant of for
What? How
extent.
can you,
My lords, there were, my lords, if I may submit this.
then we are taking it into account and then saying that you can't do it.
Yes, my lords.
You can't do it. Look, in course of the benefit from your own wrong.
Correct, my lords.
No.
A small question of law as a Muslim which we have put before the lordships and also before the appellate authorities. But the appellate authority would somehow misconstrued the entire submission made forward by us and had passed an order whereby affecting our rights. I just want to tell your lordship, this has to do with Rule 27, Code 2. The definition of no mining rules have not been defined anywhere in the rules or in the act. So no mining dues, the H1 has taking advantage of this rule has filed an affidavit with the concerned respondents, wherein they had mentioned that there is no mining dues and also had mentioned that there is no criminal case pending against them. We had tried to argue before the appellate court that a pendency of a criminal proceeding wherein the dues which were mentioned in the said FIR or the charge sheet would be made, the person can be made liable to pay that amount to the government under Rule 51. So we wanted to portray before the authorities that if there is a criminal case pending against a person and he does not disclose it in his when he is making an application, and the government may under Rule 51 may extract the money which the government thinks that the person has extracted illegally from the mines concerned and may make him pay that amount, whether it will not be construed as a mining due. Only because a lessee
But the authorities, if your lordship sees the implement order at page 104,
Suppose if there is a misinformation or a wrong information given at the time of an application, then will it not invite serious consequences to follow in the nature of a termination or a
that's
cancellation?
exactly my case. I was against the process. In fact, I was the person who informed the authorities, being the H2. We informed the authorities concerned, and we have been fighting ever since.
You are not a
No, I'm not
leaseholder,
the H1. I'm not the H1.
then,
I'm the H2.
okay.
So, the authorities
So you
concerned.
wanted to steal a march if the L1 or H1 goes. Oh,
Normally,
your vested interest is there.
I come into picture the moment he's thrown out.
Definitely, that is what your interest.
But if a law permits a person to do something in the way prescribed, he should do that in the manner prescribed.
What you have done, if he has given a wrong information that there is no criminal case pending or something, then in that event, will you not take a stern decision?
At the time of auction date, no such document was presented showing that this much amount has been demanded. No such demand notice was shown. There is no such evidence to show that this much amount is due.
There
Even
was a criminal proceeding which was initiated. So that was continuing at that point of time. Has he disclosed no criminal proceeding?
well, it's in the
In fact,
he had to file an affidavit saying no dues affidavit.
Not dues. I'm not talking about dues. I'm talking about a criminal proceeding having initiated and is pending before the court.
Yes, ma'am.
Will he not disclose?
So with regards to that, an inquiry was conducted, and in Annexure 5, if your lordships may see, in the table, there's first of all, there's identity mismatch in the FIR. It says Prakash Rautre, but here the lessee names is Prakash Chandra Rautre, so that is unverified. Secondly, my lords, when it was also asked at that point of time, it was said that there is no such information with regard to the pending dues, and after verification only they proceeded further.
File your affidavit.
Yes. And secondly, if I may submit my under Rule 46, they have an
Fine,
alternative
your-
remedy before Department of
Let us examine this. If there is a non-disclosure, we will definitely see to it.
Yes.
Mismatch, how far it can go if the identity can be established.
but they themselves have admitted they were wrong.
Or that is what I really, file your affidavit, how soon? 3 weeks, rejoinder 1 week, 4 weeks.
Rejoinder if necessary.
Rejoinder 1 week, I have said, 3, 1, 4.
Only one thing may I point out, the extraction process is one other issue model.
That can't be on your, this cannot.
So if the process
No,
is
sir.
bad,
There are 2 authorities gone against you.
so that is what exactly
That's true. So we have to examine. Interim order means we are tacitly considering everything to be true, which we can't.
But
No. That pending authorities have gone against you.
Quantify is saying that yes, Prakash Rautre bid application for this.
they themselves are saying that yes, there is a plastic pending.
Is not?
But can't.
It is considerate. Yes.
If in any
Call the next. Nothing, sir. I'm deadly against this.
time bound.
No, sir. You say 3, 1, 4, come.
We'll come back.
Item number 11.
Yes, sir. But the petition with the ex-lessee, looking at provide mines from the district of.
You wanted a refund?
My refund of annuity, my.
Refund of?
And refund of annuity, my.
What is this any
National Mineral Exploration and Development Trust.
National Mineral?
National Mineral Exploration and Development Trust, NML.
Okay.
That's the kindly space 52, my lord. Annexure 60. This is a letter of statement.
Under section 9B or rule 9B.
My
Section 9B.
we have already, we have deposited excess NMT, my.
Yes,
And
what are you
they
doing?
have to refund me.
What are you doing? Why you are not refunding? If it is an excess amount, give him.
But you are determined in view of section 86, my lord. The period was expired.
Just I received this instruction from the department. The paragraph 4 and 5 is very important.
Ball has been thrown in your court.
So we should file the affidavit because
Not affidavit. They admitted it has been deposited, but into the credit of the state of Odisha. They say that you have not transferred that money to them.
5 or 6, who will keep? Opposite part number 5 or 6, Director of Mines, Deputy Director of Mines.
Paragraph 8, straight away, nothing more than that. They have admitted, yes.
4 minutes. State is it.
But this National Exploration Trust Fund that is governed and controlled by the central government in terms of.
But they say, but it has gone to the credit of state of Odisha. So they say, yes, they admit there has been an excess payment. Now they say that it is not within us. It is with the state of Odisha. They have to process the refund. So now ball is
Para 8.
Para 8, please read.
Is
They have already determined.
deposited by the government of Odisha into the consolidated fund of India, necessary supporting document establishing the
Arrange in view of the above, please arrange to refund this much amount by government officer. So that's why I'm saying whether 5 or 6, who will disburse?
But the
4 minutes. Statement.
4.
Right. Your Lordship may kindly see that last paragraph of para 8. The last paragraph. There is a subsequent paragraph.
In case
the said amount has been deposited by the government of Odisha in the consolidated fund of India, necessary supporting document establishing the transfer of the amount.
Because you have to establish what they will do. Sir, their right is crystallized that they are entitled to refund. Now may I say it's like a ping pong game. They are shucking their responsibility. You are shucking your responsibility. Now the government of India and the state of Odisha fighting each other. We don't know where the amount is. What he will do, a poor person whose money is being utilized either by the government of India or state of Odisha? Who will pay?
So this money is of NMUD.
National Trust Fund below, so far as state of Odisha is concerned, they have limited role. They collect and deposit it in.
Sir, it has been deposited in a
central government.
Mr. Das, it is deposited in a contingent fund, not in a particular fund. Contingent fund under the constitution. Every state, the center, they maintain contingent fund. Not earmarked for any budget.
Let me take this.
That is also made clear. See, paragraph 4.
Consolidated fund.
Paragraph 4. That head of account pertains to state of Odisha.
listed for first time. So
Mr. DSG, I have been very critical in the morning when these kind of submissions are made. That it is listed for the first time.
First time listed and
No, sir. Sorry, I will not accept.
No, this I think service of copy was much earlier.
based on that we take it.
No, sir.
But this letter has been produced just now. Let me take instruction on this. What is happening? Let me just find out. Well, this is addressed to the Additional Chief Secretary, Department of Steel and Mines. So let me take instruction. What is it? The letter is undated. There is no date in the letter.
Yeah, the second page there is.
This is such a innocuous litigation.
Verify the head of account where
Yes.
this deposit. So that can be.
The
And it is within yourself.
the instant writ petition
In this case, my lord, with respect to same lessee, my lord, petitioner claims interest, my lord, because they have withheld my money for a period of 3 years.
Along with that.
That who will take instruction?
State.
Same, state.
First thing is, let us ascertain the liability or the responsibility. Then the question of interest will come.
Item 13.
Was the refund has been effected?
Unjust enrichment of their legal rights.
But in Malap, from behalf of the one story is on his legs and
Not on his feet.
I only put one passport, and let's say, no, he's good. No.
Item 14.
13 as well, very fast. My learned senior, Mr. Vikananda is also arguing another matter in a court.
Next.
Item 15.
I think just one passport, Lola, there will somewhere similar to that, it's another just one passport.
Next.
Item number 16.
But here in this case, the petitioner allocated this one stone quarry for a period of 5 years. That 5 years was scheduled to be over on 27th of December 2025. Not prior to that, I applied for an extension. I filed a representation before the competent authority to extend my lease period for the period.
Under what provision of law?
I have only relied on taking into consideration rule. Rule 59 of Orissa Mandatory Concessions Rules.
59?
Yes, 2016.
Yes.
Prospecting license or mining lease or quarry lease obtained in contravention of the Act and rules. Any prospecting license or mining lease or quarry
It says it shall be void and of no effect.
/ renewed. So the word renew, even though the word renew is
Whatever I understood what you wanted. Suppose a particular word is used without creating any right of renewal. Can you?
Then in that case, also has to harmoniously read the provisions envisaged under the.
I just wanted, there must be a right conferred upon the authority for a renewal or an extension.
Yes.
There is a gulf of difference between an extension and the renewal. So the renewal connotes what?
In this petition, I am not challenging my rejection on that ground. I'll address that question also. But here, they rejected my application.
What you will address? What is the meaning of the word renewal?
Renewal is the period initially there under the agreement, that will continue till the time of it.
That is an extension. Then what is the meaning of word extension?
Extension will start from the date of expiry of the original period.
And the renewal will start from the date? From this date?
No, a prospective date.
Then extension is not prospective.
Extension can be granted prior to the date of expiry, and it has.
Can it be granted?
Extension.
Are you very sure about it? Then may I invite you to read a judgment of the Supreme Court in case of Prabhas Chandra Doloi.
And Odisha High Court, my lord.
Prabhas Chandra Doloi judgment. So read that judgment. Relying on a 1973 judgment of the Supreme Court in case of Delhi Development Authorities. The distinction between a renewal and extension. It has been defined that the renewal means re and then newal. So re means again and newal means fresh. So it is again a fresh. And extension means prolongation. stretching further.
Original.
Read that judgment. PROVAS or SH, whatever. Pravas Chandra Doloi.
Dalui.
Dalui or Doloi?
DALUI.
LOI or LUI?
LUI.
What's my famous one time? Even though this is not the case for extinction.
That's the irony here. The moment I put some question, it augments the adjournment immediately.
But I mean, but this is not the case where I am praying for extinction.
Sir, you are referring to clause as Rule 59. You say that the word renewal is used therein, that connotes that there is a power given to the authority to renew.
It is not absent at all.
Whether there is a conferment of power, one can. What can be logically deduced is something different. And what the power will be clear, lucid, explicit.
Next Tuesday.
Have you not got that judgment?
Yes.
No. You got the judgment? Reported it in 1988 or 1998?
1998.
1989.
89. What it says, renewal and
I read my words, the one. To extend means to enlarge, expand, lengthen, prolong, to carry out further than its original limit. Thus, extension ordinarily implies the continued existence of something to be extended.
renewal.
The distinction between extension and renewal is chiefly that in the case of renewal, a new lease is required, while in the case of extension, the same lease continues in force during.
That is what, sir. So, you are interpreting renewal.
No, this rule 84. Rule 84 says
84.
Rule 84.
Achha. But it says?
It says that the minimum period for which the query is to granted is 5 years.
So, no, I do not find 84 in here.
No, Rule 8 sub-rule 4.
Is Rule 8 sub-rule.
What it says, the maximum period for which a query is may be granted shall not exceed 10 years and subject to such terms and conditions as may be specified by the competent authority, provided that the minimum period for which any such lease may be granted shall be 5 years.
So
the minimum
it's a duration. It's a duration of a lease. It has got nothing to do with the extension or a renewal.
So that
is a duration. What instruction?
He's saying the discretion is granted to the government, the authority to extend or renew that lease period for 5 years.
But the discretion must be exercised within the framework of law.
In absence of any such,
there is a very fundamental principles which always I say is the first principles of law. That an individual can do anything unless prohibited or forbidden in law or forbidden by law. An authority cannot do anything unless provided in law or by law. Can they do? If there is no power for exercising the discretion, can they exercise?
In absence of any such restriction or any such...
That means they can't. Just let me understand the proposition of these legal principles. I am very candid. I have not come across with this. Be sure.
But in one case,
take assistance of your instructing friend.
One of the cases, the Honorable Supreme Court was interpreting the phrase not beyond 2 years. No, I had also handed over that copy of the judgment in the last hearing in related to this volume of civil law. There the Honorable Court said, since the phrase used that it can be up to 2 years, it cannot be construed that it cannot be granted more than 2 years. Will not hear the language.
I have in a different context.
Yes,
I know the different judgments in a different context may not be in relation to mines. I know the judgment of the Supreme Court which says that when an outer cap is fixed beyond which the power is not conferred upon the authorities, it cannot exercise such power. I can give you an example of the Arbitration and Conciliation Act, where Section 34, application or an appeal, outer limit is given. It is inflexible once you cross that outer limit.
90 days plus 30 days is over.
Whatever. I can give you an example of the Commercial Courts Act, where the filing of the written statement outer cap is given beyond which it cannot. Here, in many of the judgments of the Supreme Court, no power vested to the court beyond that. Say in case of a GST, where an outer cap is given in relation to a appeal before the appellate authority. Courts have held no, beyond that can't.
But it also means that there are also instances where you also have taken note of the fact that whether the particular word has been construed as mandatory or directly.
You are talking about the amendment in the Code of Civil Procedure regarding Order 8, Rule 1. And no outer cap is given, sir.
Not insofar as there are not.
And I am conscious of the Kailash versus Nanku judgment of the Supreme Court as well. Salim Bar Association judgment of the Supreme Court, I am conscious. Yet, one has to understand the law in that. No, sir. If you say, then I can.
This is not my case. My case is different. My case.
Your case is that you wanted an extension or a renewal, whatever.
Yes.
My query was that where is the power of extension and renewal?
But they rejected me on the ground that your claim for extension can be. Here there is nothing. You will not kindly see the rejection order. They said that my.
Forget about it. The question is whether they have a power or not. They may reject it. Wrong finding. Ultimate decision is no right.
But I have no right. But your lordship has also directed at many occasions to consider it, taking into the.
That they were doing it, we were sometimes.
But here I have never.
Sometimes, for some reasons, do not say so.
As a matter of fact, I have never operated the query. No white form ever issued in my form.
Pray for compensation.
I will
pray for compensation.
They have straightly rejected my case on the ground that my case has been cancelled. So therefore, the prayer for renewal cannot be considered. What's my kindness?
Regarding the lordship's observation in outer cap was a judgment by the lordship's Fort Mallards. Vidyadhar Patra versus State of Orissa. And if I may read the relevant.
I was the counsel in that case, and you also directed the party to approach the authority and doctor to take a final call regarding the extension and renewal of the claim. That order may be passed in this.
That is.
Here,
I can't. We are live, otherwise I would have said many things.
Is that for a single day that I was operating the mines?
No, sir.
And secondly, my prayer is to ask the cancellation of mines order. Unless and until the cancellation of order is said, I cannot pray for extension or renewal. The state have rejected my application on the ground that I have never operated the mines and therefore it is cancelled. And the cancellation order has been passed by the mining officer in charge. Now, my specific case is that mining officer in charge, he cannot pass a statutory order. He is devoid of that power.
Where is the provision?
It is defined under the rule that the competent authority is the mining officer. And unless and until the rule delegates that power to someone else or the person who
And I'm not, I'm
No, 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 no. Let me first you frame the
Yes, Your Lord.
principles. First frame the principles
The
of law.
principle is that when there is a statutory authority provided under the Act,
Correct.
same statutory person or the person who is holding that position, my lord,
Correct.
he is only empowered to pass.
So who is the competent authority?
Mining officer.
Mining officer.
Yes, sir.
Competent authority is defined in
Yes, sir.
2F
Yes, sir.
of the rules. Is it?
Yes, ma'am.
Yes. Where is the schedule 4?
Lord, it last page of the Lord, page 116 of our
Yes. You are a minor minerals or a specified minor?
Minor.
Minor minerals. Are you having a quarry lease or a quarry permit?
Quarry lease.
Quarry lease. It is within the village boundaries or outside the village boundaries?
Within village boundaries.
Huh?
Within village boundaries.
Is it within the forest area or outside?
Outside.
True. So according to you, the additional mining officer
Mining officer in charge.
in charge. Okay. He cannot.
He cannot.
Because there is no mining officer. The post is vacant. So if the post is vacant, so according to you, the entire thing should be kept at halt. Nothing can be done. No.
Not, I should not be taken otherwise, my lord. Here in this.
No, I'm not taking. I'm just asking you.
Yes, my lord. My lord,
What is the meaning of the word in charge?
My lord, he is not the statutory authority. What I'm, my lord, trying to canvass with your lordship, that he can at best be done. He can at best be doing the official work, my lord. Insofar as, my lord, that is not statutory in nature.
Correct.
Quasi-judicial power he cannot exercise. That is what you are.
It is my conclusion. It's my conclusion that he can at best be doing the non-statutory works related to its administrative, my lord, scope.
What remains then in an office? In an office,
Look, mining officer is not.
in an office, if in charge would not discharge his duties as conferred under this statute, what remains for him to discharge in an office?
Mining officer has a
what other? Tell me. Tell us.
Many other.
What other administrative work he will do? Disbursing salary
That
or granting promotion? Or he cannot.
The scope and power of mining officer and the service, ambit of that service, I am not aware of. But my humble submission is that it can be guided on.
It is not in persona designata. Is not. If it is not persona designata, then what more? He is holding an office, discharging the functions and the duties of the mining officer.
But he is not the mining officer. So therefore,
what are you in charge means what?
Well, in charge is temporarily officiating a post which and in every
consider in a judicial aspect.
In fact, that is what I am saying. Honorable Supreme Court last month only directed the Registrar General of Punjab and Haryana High Court to produce all those case records where the in-charge judge has passed the orders and they found to be defective.
In-charge judge means?
The judge was not absent, and in his absence, a file was marked to some other judge by the district judge or by the judge who was entrusted with the power to this file to allocate the files. But the Supreme Court, said this is very strange that if judge who is in charge of a particular judge on a particular day, he cannot pass the final order. This is the observation. And this case is pending, but the interim orders, the orders passed in that case, I am just producing.
No, it is like that. On a particular day, suppose district judge is absent because of his preoccupation or so the file automatically goes to the senior most judge or the person who is authorized.
It is a question of malice. It's a question of malice or is a question of malafide. When there is already, if the office is vacant. That there was no office which was vacant. A person holding the office was on leave or for a certain period was not there. And there, if something is done by an in charge,
Final order.
I'm telling you, this is final order. That is what is there. If the office is vacant, then
That person himself is officiating in a temporary.
sorry, you know from the core of the heart what is the effect of it. Arguing for the sake of your client, I appreciate it. But yes. No. Bye. Call the next.
Item 17.
Item 17, and under the inaction of authorities for not alerting in alternate space to operate the stone quarry. Earlier, I was a successful bidder to operate the stone quarry of Subarnapur district from 2024-25 to 2029-30. Thereafter, requisites.
Why did you consider? You can't do it.
In the rules, there's a provision for substitution of quarry.
No, because every query has to be
Yes.
given by auction.
Yes. Further,
And it is a separate and independent incident.
please, by the time I got the consent, there was a construction of bridge work was started, and there is illegal.
Back the entire money if you have put a.
This is first time hearing will be issued today to her, and therefore this the letter which she has submitted as the last annexure that will be heard matters. So that opportunity may be given so that even the one constructing the bridge was both.
Basically, you are encouraging this representation theory. If she cannot assert her rights of substitution, then it's a farcical exercise to have the hearing and then reject the representation.
Regarding the payment of the.
What to do? Entitled to a substitution. If you have paid the amount or not, so will you not report?
No, it is there. I have paid. Even lease deed was annexed to it is there. I have paid the total amount. Even mining plan was approved. Thereafter, pollution control will clear the approval, and thereafter, accordingly, lease deed was executed. And 15 on finally on 11,025, I got the consent to operate the stone sand quarry.
But in the meantime, the bridge has come.
There was already at the time the construction of bridge work was started, and the contractor who was the bidder illegally lifting the sand. There is no. It is difficult to move any vehicle to operate to lifting the sand since there is no plug. Already the sand was already been lifted by them. Huge amount of sand was already been lifted.
By
the contractor who is
how can he? Has he got a permission?
Since he has been awarded to construct the bridge work, my lord.
So he can lift the sand from the riverbed or anywhere. Can he? Without a permit or without anything?
It happened and it is there. And
So why you are not stopping it?
with regards to the permission has been granted or not, that I'll confirm, my lord, because that is not there in the pleading. Also, whether any permission and such are legal granted. So with regards to that, I'll confirm once, my lord. But otherwise, the action of the letter would be.
Sit down. Consider the representation for compensation. Return. Yes.
Item 18.
Wait, please, Your Lordship. Item 18, Your Lordship. I am for the petitioner. My Lord. Item 18, my Lord. Here the petitioner who has given a lease of stone quarry, Your Lordship. May I submit, my Lord?
You are submitting us.
My Lord.
Again, the same question.
My Lord.
Where is the provision for extension?
That is, Your Lordship. That is 64, Your Lordship. It is up to the government to consider. There is some difficulty.
Show us 64.
That is Odisha.
I have been asking everybody to show me that provision.
My Lord. Odisha Minor Mineral Concession Rules 2016.
Yes.
That is 64. The government.
That is the relaxation of the rules.
Relaxation, Your Lordship. What has happened in this case, Your Lordship?
Is a state government.
My Lord, I am producing a very similar order. Your Lordship has passed. What has happened, my Lord? Here the query was under the Revenue and Disaster Management Department. Now it was changed to Mining Department. For that 6 months, I was not given the transit permit. That is admitted fact. They are admitting it. Absolutely no fault from my side. Change of department in between from revenue to the mining department. Your Lordship, that is also the what I have obtained that the and I am submitting a date chart, Your Lordship, relating to this.
Have they taken a decision or not taken a decision?
I will file a fresh representation. Your Lordship, may kindly see the date chart.
No, have they taken a
No, my Lord, not taken.
You have approached them?
I have approached.
Where is your representation?
That is Annexure 5, but it is not a
You take a decision?
I'll file a fresh representation within 15 days.
No, same representation.
Same. Yes, Your Lordship. Yes.
Annexure 5.
Page 45. I'm submitting one date chart, my Lord. Wherein
not necessary.
My Lord, the relevant dates were there.
Only let them take a decision. Yes, brother.
May I produce a similar order, Your Lordship?
Relaxation of
that is Lordship has passed on 6/1/2026.
Yes.
On 32657 by 2026.
Call the next item 19.
Your Lordship has taken a similar view.
19.
Directing the government.
Item 19 is also a matter for, I'm seeking extension of the lease period. May I first satisfy your lordships on the facts? Well, it's
on law.
In law, well, it's
Show us the power.
Yes, ma'am.
Except 64, any other.
I want to take your lordships to Rule 8.
It talks about 2 years, 5 years, maximum 10 years.
Maximum 10 years. Before my submission, my lords, is that there is a discretion granted to the authorities to consider to give me a lease for either 5 years or 6 years, 7 years, 8 years, 9 years, 10 years.
But not exceeding 10.
Beyond 10 years. They have given me a lease for 5 years.
So that is up to them.
And
they could have given it to pen.
Yes, well, what I will show to your lordships is that due to the delay and latches by the state government in demarcating the lease, I will show you lordships admitted documents. One document only I will show you.
You have already taken a decision that you are entitled to refund of every amount.
Your lordships will only see Annexure 11, page 74. One document. Annexure 11, page 74.
What?
This is from the Deputy Director of Mines, Khurda Circle, and he is writing to the Tahsildar. And
maybe that you take decision for extension.
No, Melons. He says, with reference to the subject cited above, Pratap Kishore Mohanty, the successful bidder of the Noyakote laterite stone quarry under Tangi Tahsil, has already reached an agreement on February 9th, 2021, and all statutory documents are valid until the period. But the lessee hasn't operated the source due to the opposition of some nearby localities. I would request that you please demarcate the lease area with revenue officials in the presence of ILC Junkia so that the lessees can operate the source. This is dated 14th of December 2023. They finally demarcate my lease on 18th of July 2024, by which time 3 years had already passed, and I have paid on the minimum guaranteed quantity. I have paid royalty, I have paid additional charge, I have paid DMF, I have paid NME.
Get back.
Well, your lordships have directed that they will consider my application.
Get back.
Your lordships have paragraph 8, the last paragraph at page 11.
Yes, said in some cases.
And well, more importantly, your lordships have said in the event the authorities decline to extend the period or renew the lease.
Because we have said that we have come across with certain, we have said that this power is not there, but we have come across. We do not want to make any comment on the authorities and say in the event it is there, refund with 6%.
Yes. Well, only one addition. Because the refund includes
one subtraction.
If the case जाइए,
no addition, subtraction.
Well, apart from security deposit and advance royalty, I am also paying several other charges under Rule 32(3), which are compulsory.
These are all statutory charges,
which I am paying despite due to no fault of mine, I have not been allowed to operate the lease.
Yes. It's called the next matter.
I do not want one.
All the three matters are same.
Only I told you.
Okay, withdrawn all the three.
But my presentation is at Annexure 30.
Yes. Item 21.
Cancellation.
Under Annexure 1, where they raised the demand of the section 21(5) of the MMDR Act relating to penalty.
Yes.
But here the lessee, petitioner lessee was having a lease for quars and quasi. Now referring to that common cause judgment, they have.
Yes, they have said that the expression any land not only mean outside the leased area, but within the leased area as well.
Having statutory permission. That will be treated
If there is any violation within the leased area, it will attract 21(5).
Question is whether this is a lease for quars and quasi. The common cause judgment relates to iron and manganese.
So any ratio which is decided or laid down has to be restricted to, then it will not apply to coal. It will not apply to zinc mines. It will not apply to iron ores. It will not apply to any other minerals.
Whether it will apply to already 600 court has applied many matters on exactly this question.
You just give me so that we will dispose of or dismiss all those matters. But if this is the point that common cause is only restricted, then we will dispose of. Give all the numbers. Give the numbers.
WPC number.
How many has been admitted?
3 matters.
Yes.
WPC 30268 of 2023, WPC 40839 of 2023, WPC 40946 of 2000.
All these matters to be listed. Yes, ma'am. All those matters.
Next, one more something. In the meantime, madam, this is 131.
The common cause has taken note.
The legal authority.
It will be treated as without authority.
It says only 3 instances. They say prospective. I understood prospective licensee. Then the another 3 instances. So the other instances.
Here the petitioner.
Don't worry.
Is a leaseholder man.
I've seen. I understood.
That amendment was in the year 2021.
21.
Says in 2025. And so this.
So I am aware of this. When that bill was placed on the floor of the House of the Parliament, the mining minister has said so that this was a confusion which was created because of this common cause. I know. Let me decide that matter as well along with that.
In that case, the demand.
That was under 21. After 21(6), it was inserted. Explanation. Not after 21(5). After 21(6).
So this explanation is clarificatory.
Let us see clarificatory in nature or a declaratory in nature. Let us see what it means. An argument is advanced that since it contemplates 3 instances, other instances are outside the purview of this. Let us examine.
Demand may not be enforced in that. But in all those matters, may not have protected in all those matters, may not have protected. If you are taking the decision, let it not be recovered.
We are keeping this matter next week. We are keeping this matter in the next week. Keep it on Tuesday.
We are going for coercive.
Item 22.
We are not passing an order, just see to it. We are keeping this matter to be decided. All the matters.
Item 22 matters are placed the customer.
The extension of lease. Item 23.
Here we are the petitioner place for direction to issue our form so that we can operate the query. The matter is like this.
Our form is
To operate the, to take out the stand of the sand stock. Whereas sand stock was settled in 2016. In 2004, under annexure 1, the lease deed was executed. That this did it prospectively from 2016 and issued a letter under annexure 2 that your lordship will find, kindly find at page 47, as page 47. It is hereby brought to your notice that you have been authorized to operate so and so river service from till 25/4/21 as per lease agreement dated, that is annexure 1. Since your lease agreement is going to expire, this I challenged before your lordship. This, when I challenged, your lordship passed the reasoned order, that is at page 48. But I am placing the first paragraph and the last paragraph so that your lordship don't bother. The petitioner was successful in the sand Sarat auction conducted in the year 2016-17 and was ordered the said Sarat for a period of 5 years. Has come to this court in the petition for a direction of the opposite parties to allow to operate the query lease for a period of 5 years, commencing from 4 December 2020. Lease, that is the lease period. The date on which the lease deed was executed and registered. He has also sought for quashing of an order dated 1921 of the Tahsildar was that annexure which I placed, stating that since the period of lease was going to conclude on 25/4/21, the petitioner should stop lifting sand from the source after the sand date. Now, your lordship need not go to the deliberations. Kindly come to page 50. The conclusion which the court arrived at paragraph 6 of the judgment. Lordship, what? Page 50. Paragraph 6.
No, I understand. I was just looking because this was a 2004 rules, and the 4 rules say that the lease would reckon from a date when it is registered, not when it is executed. So I was just looking at 61 provisions.
I was about to place, but
No, I have just read it. I have seen that it says from registration. According to you, the registration was in 2020.
2020.
So 5 years will reckon from 2020 onwards.
So what happened, Lord, when your lordships passed the order, operating portion is like this. Paragraph 6 of the judgment at page 50.
So that is what it says, the register.
The relevant part, the important part is paragraph 9. It is clarified that the period during which the lease has been stopped, that is 27th April to onwards up to the date on which it was allowed to resume on the strength of this order, will also be counted. But thereafter, retractism came in and the file could not move. The law changed. The law changed. This also drew your lordship's attention in the division which of this I have annexed that also. Your lordship, after considering all the aspects, have come to the conclusion that after the amendment, the mining officer will have the jurisdiction, this Tahsildar will not have the jurisdiction. So, at page 67, your lordships directed, issued this mandibus.
So that all the matters for our files to be transmitted to the mining officer.
Yeah, but now I am like a shuttlecock. The mining officer says that I am not a party to that proceeding. I cannot do it. The Tahsildar says that I have lost.
But that was in relation to 2004 rules.
4 rules.
So, and no amendment because that has been repealed.
But that's so mining officer has to take a decision on your lordship's order. Mining officer has to take a decision issue.
But mining officer is not a competent officer in 2004 rules. Amendment was brought in 2016 rules. But 16 rule does not apply to your case.
So therefore, therefore, Tahsildar at least should have that.
Whatever, that is what we wanted to.
I am not so secretary if the Tahsildar does it. I wanted to
because you have been it's like a shuttlecock from one court to another. What is this?
But I have taken because the instruction I have no objection. I have to forget business plan.
Tahsildar instructed one letter or receipt to the prisoner to submit certain documents, mining plan and other modified mining plan. It was not submitted for the Tahsildar for the
I don't find anything. Where from where?
That's for instruction I have received.
To take instructions to week.
Okay. Let them file an affidavit, so we
not affidavit.
What he is saying is not on record.
Then in the meantime, it is open to the respondent to file a counter.
Item 24.
It's not that having a sanctuary as this explained today, but for different reasons to put for circumstances beyond his reach would operate for some of the operate for extension of the lease. Well, option can you see the government of the letter. In similar matter, let's pass each other. Option can you see?
Where is the government's letter?
Government letter, there in this case, the government has also said they don't have any power. But the Lordship have dealt with that aspect and dealt with their contents. The Lordship Para 3 Lordship Para 3.
So that is a submission.
No, Para 3 submission. They say that they don't have any power. Then the Lordship relying on
64. I think the state government can relax. So that is what is there.
I want to leave this.
But we have not said anything.
No, yes,
68, relaxation of a power is something different.
But if I say so, the Lordship kindly talk to page 64. What the government has said.
But the same thing.
Page 64.
Huh? I think the identical order.
No, also my application is digital only limited. So.
Yes.
Page 64.
Next.
Only that part.
Yes.
Similar 64 plus rule 64.
Item 25.
What is it?
Both to realign.
The extension of minor labor laws. Dr. Your Lordship in Vasant Kumar Market's case, he please to pass just like
64. Wrong.
to the left to the government.
Wrong.
Your Lordship has been pleased to
Wrong.
wrong. Your Lordship, you.
I am bold enough.
I participated for the purpose of not clearing this mine by 50 crore and deposits.
Kalinga was defeated by Lord Ashoka. Now it's defeated by State of Odisha.
State of Orissa. Only
or government of Odisha.
Since Lord June of 24, I have completed all the processes and the Orissa Pollution Control Board has also written to the two district magistrates to do the public hearing. 18 months to public hearing is held. So I have done whatever was to be done. My 80 crore 20% deposit is there as a preferred bidder. My 50 crore plot pre-deposit is there for the purpose of bidding. Now they say, and they rule permits plot for extension by 2 years. Just have a look at that rule.
Where is that? This is in relation to?
This is mineral auction rule. Major mineral. The rule is quoted plot. Is that the petition?
Let us see.
Yes, I just show them.
No, mineral auction rules. I think it will be here. Oh, it is here. Yes.
Rule 10 of the mineral auction rules, Lord.
Does it come to page? No, come to page 357.
If your lordships are seeing rule 10, then sub rule 6 second proviso.
It's not been
That is in relation to an execution of a mining lease. It has got no relation to the continuance of the mining activities. That's two different facets.
We have not reached the mining activity stage in this stage. We are only a prospective.
The lease deed has not been,
the lease deed has to be executed.
Not executed.
Within 3 years, it has to be executed. It can be extended by 2 years if there is no fault on my part.
True.
And I in the petition note, I've shown that I have been asking for a public hearing for the last 1.5 years, and they have not conducted the public hearing. And as per the EIA notification, within 45 days, they have to do the public hearing.
Because this rule 10 contains the timeline for every action or the steps to be taken by the
I have taken
authorities
all
as well as
I have taken all my steps, and it is lying at their end. My repeated letters to them asking of Lord, there is a further complication which I must straight away point out to your lordship. Lord, just have a look at page 212 of the petition. There is an amendment to this rule. But fortunately, it is a prospective amendment, so it will not affect me at all. Just see at 212 in the petition. 17th October 2025. My award is not February of 23. And it says these rules may be called the Mineral Auction Rules, Second Amendment, Rules 25. They shall come into force on the date of their publication in the official gazette. Now, please see in Sub-Rule 10, Clause 3 of this, Sub-Rule 10, in Sub-Rule 1, it says, for the word 15 days, the word that triggers furnished performance security as specified in Rule 12 within 45 days. For the proviso, the following proviso shall be substituted, namely, provided that in case where the preferred, now this is as far as Sub-Rule 1 is concerned, it is retrospective in one sense.
It is already declared before the commencement of the Mineral Amendment Rules.
So this is not my problem.
Well, for this, within the 6 months of the commencement of the rules, in case of the failure,
that will happen in April, so I'm not worried for that. Although I've challenged the rule. My problem is Sub-Rule 6.
That is in relation to a promising of performance security.
200 crore performance security. And that timeline is still till October.
That is up to 6 months.
It's still April. So my problem is Sub-Rule 6. This is not retrospective. In the second proviso, for the words, if the reasons for delay were beyond the control of the preferred bidder, the words, if the state government is satisfied that the preferred bidder shall be able to comply with all the requirements for execution of the mining lease deed within such extended period, and the preferred bidder has paid all 3 installments of the upfront amount before allowing such further period. Now, this was not there in the earlier rule. The rule did not require me to pay the second and third installment if the delay was on the part of the state government. Ex facie, this rule is bad because where the earlier rule said if there is no delay on my part, then only I would get an extension. Here, even that they remove. Even if there is a delay on my part, still they get extended. on a case-to-case basis, looking at the face of the person who's having this, who's the preferred bidder. So this clause will not apply for me. Now, what they have done, the latest call letter which they have issued to me, which I am wanting a stay now immediately, lot is at 220.
Yes.
220 lot is the letter dated 22/1/26. So first is they are talking about performance security. For the time being, I am not arguing that. Now please see B. Second proviso to Rule 10(6) of the Mineral Auction Rules 15 state that the state government may allow a further period of 2 years for execution of mining lease deed if the state government is satisfied that the preferred bidder shall be able to comply with all the requirements for execution of the mining lease deed within the said extended period, and the preferred bidder has paid all 3 installments of the upfront payment amount before allowing such further period. However, Kalinga is yet to pay the second and third installment. So second and third installment is 320 crore. 320 crore, they can't ask me under the old rules. If I'm not at fault. If I'm at fault, then definitely they can ask me, but if I'm not at fault, they can't be. That's the rule, the original rule. This is not retrospective. The rule itself says it is prospective. So rights conferred to me under the old rules.
What is the distinction between a substitution by way of an amendment, insertion by way of an amendment?
So this is not a clarification.
Is a substantive right. It says substituted. Then once it talks about a substitution.
Substituted, but it says will come into force on the date of
that was in relation to the other instances. If it is
just I'm so sorry, bro. Just have a look at page 2 once again, bro.
Please.
This whole amendment is said to be prospective.
Where it says it will come into force from the date of the notification. That is what is there. It will come.
It doesn't say that it will apply retrospectively.
Then the intention has to be gathered.
Now, I'm trying to make is this. Under 10(1),
yes,
they talk of a preferred bidder from before.
Yes.
And they say this will apply, he will also have to give within 6 months. So to that extent, they make it retrospective. Your Lordship, Supreme Court has said always that if you want to make it retrospective, although there is a judgment of the Supreme Court which says under the Mineral MMRD Act, you can't have a retrospective rule at all. Supreme Court has said. Because the section which authorizes them to make the rule does not authorize them to make it retrospectively. I'll just show that also. But I don't need to go that far. This 10(1) proviso can be said to be retrospective because they talk of an earlier bidder. But then 10(6) proviso is not retrospective. It don't say that it will apply to people who have already been. So 10(6) will apply only prospectively. So a bidder after this date will be required, and if he delays, and if there is a delay beyond 3 years, bidder in the 10(6) proviso will be required to pay second and third installment. Although expressly this is illegal, I've actually challenged the virus of this rule also in my petition. My prayer is to declare this rule unconstitutional, because where the initial rule required me to get an extension only if I was not in default, in the amended rule it can be given even if I am in default. And the only requirement is of payment of this money. So this is a complete departure from the original rule. Original rule says I should not be in default. This rule says even if I am in default, but I am ready to pay money. Just see the distinction. Now, Lord, even if I am in default and if I am ready to pay the money, if I have got deep pockets, I can still be continuing with the lease deed. So I am only saying, Lord, that this 22nd January should be stayed so that they should not go back. 3 years is expiring, Lord, on 26th of February. That is my difficulty. LOI is expiring on 26th of February, and the result will be that they will forfeit by 80 crore, they will forfeit by 50 crore. And no fault of mine. No fault of mine. It's and if, as your Lordship remarked in the earlier case, there was no power to extend. Here there is a power to extend. Here clearly it says that if I am not in default, and if you just have a look at those documents also, Lord, just see in the petition, these documents which I just want to show Lord the option, Lord. I asked for 22nd, Lordship, kindly note, I pay the 80 crore on 17th of February 23, and then I made a console, but I'll not need all of it. I'll just need a couple of these. Just for completeness, your Lordship, having that one place. So I pay the 80 crore lot on 17th of February, which is serial number 4.
Show me that judgment that it says, the apex court says that there cannot be any rules to operate retrospectively.
I just show them. Just see plot serial number 15 then. What was to be done by me? Serial number 15. The mining plan is approved.
I understand. Validity 5 years.
No, 16 TOR is also approved. Then we not see 17 Odisha Space Application Center also we not approved. Then we not 18. I submit a draft environmental action plan. Under this 45 days is the public hearing. And 19 is very important. Lord. Just see 19 at page 128.
Conducting for the environmental.
Yes, so, but Pollution Control Board tells them to do it. And under the EIA notification, it is to be done within 45 days. This is as early as on 21/6/24. We are in 26. That public hearing has not happened. That's the only stumbling block as far as this.
Where is that judgment?
Now just see that that is Federation of Engineers, Lord. This will be plot 2017-16 SEC 186. Running page 59 of the compilation. So 13 is quoted plot in paragraph 5, the rule making power. Question is in paragraph 18. In fact, the amendment is quoted in paragraph 17. These rules may be called the Mines and Minerals Contribution to District Mineral Foundation Amendment Rule 16. In the Mines and Minerals Contribution to District Mineral Foundation Rules, for Rule 3, the following rule shall be substituted, namely, the amount calculated at the rate specified in 2 shall be paid with effect from 12/1/15. So that's how they want to make it retrospective. But you have seen the rules, Lord, 31/8/16. 31/8/16, they say it should be made effective from 12/1/15. And then in paragraph 18, the question is raised. On the basis of these notifications, the question raised by the learned counsel for the petitioner, firstly, whether DMF could be established with effect from 12/1/15. Secondly, whether contribution to DMF was required to be made at the rate mentioned in both these sets of so-and-so and the validity of the notification. And then see the finding, Lord, at paragraph 26. The power to give retrospective effect. I'm sorry. What is that paragraph 26? Since your lordship read very fast, I don't know where your lordship.
No, I am reading from the first paragraph. Don't worry. I have already gone up to paragraph 18.
At 26.
Just give me 30 seconds more.
I'll wait, Lord. Paragraph 26, 27, 28. What is that paragraph 20?
I've gone to paragraph 29.
Oh, very good.
No, I have seen the Hukum Chand case and all, everything has been considered. It says,
classes
so far as the subordinate or delegated legislations are concerned, unless the parent statute provides or confers the power to make it from a retrospective operation, then only it can be done.
That ground,
Otherwise,
performance security will go. Literally, even performance security can't be changed for me. But unfortunately, my prayer is not an element that, because this probably the briefing lawyer did not realize this legal position. Because the briefing lawyer was of the view that if the performance security is retrospective, then 10(6) is not retrospective.
No, that was in relation to a DMF because they wanted to set the trust from an anterior date or a retrospective date.
Rule is to ask.
It was saying that it has to be from 21/2015. There were 3 amendments which was brought in the meantime, which says it will take effect from the date 12/1/2015.
Which is
And
what is
therefore,
challenged.
this is what was sought to be
And
challenged.
it's
with
it
that.
can't be retrospective. So my respectful submission is this, Lord, that the lease by 3 years is expiring on 26th of February. I need a stay for this demand and not any coercive action so that not Lord terminate my lease.
This is the extended period or
No, original. I'm still in the original. I'm still in the original 3-year period. And the date on which I asked for the Orissa Pollution Control Board asked for a public hearing to the district magistrate is Lord of June of
2024. That you said.
7 June 24.
What he says. What he says.
Kindly see the impugned order. The impugned order only says that extension the letter of
The only thing is that what he says is that by virtue of this amendment having brought subsequent to the declaration of his status as a preferred bidder or a successful bidder, cannot operate retrospectively because at that point of time, the provision stood that in the event there is no fault on the part of the preferred bidder or a successful bidder, then he is entitled to an extension up to a maximum cap of 2 years.
2 years.
Now, by virtue of this amendment, they say that yes, this fault or no fault liability or a faulted liability that has gone. It has been effaced from that particular provisions. You say that yes, you are entitled to extension provided you pay the entire dues of 3rd and 4th. He says that why it was not my obligation or at the time when I was declared as a preferred bidder. Secondly, though it has not been said in a very express terms in that particular proviso, though he is referring the earlier one in some, but still he says that by virtue of this mineral judgment, subordinate legislation cannot operate retrospectively.
Co-MMRD only for this act, this section rule.
They challenge both. They say that the statute is.
I am not saying anything on that. That what the principles that would emanate from here. What is your reaction?
The statute, they have challenged the virus of the statute.
That is alternative. Court prayer. Alternative.
That is the alternative prayer, but that is the only prayer because the statute prescribes that. Now, my lord, the petitioner is continuing to be a preferred bidder, not a successful bidder, as per the requirement of the statute. He is yet to deposit the 2nd installment and the 3rd installment.
But the question is that if there is no fault, then in that event, you are supposed to conduct the public hearing. The lease deed cannot be executed 3 years timeline, which is already given in the act. You have already crossed the deadline. You have not been able to do it. Whether they will be saddled with the liability, if there is no fault or there is no lapses attributable to their conduct, then how? Forget about this judgment. I will deal with this judgment that what it means. I am talking on that.
Lordship, may kindly see the statutory provisions. That is Rule 10. Rule 10 of the mineral auction rules. Now, my lord,
the bidder shall submit the first installment of upfront as per the rule 11 within 15
That he says that I have already deposited the first installment upfront.
Second,
and then the timeline. Then the second proviso that was inserted comes.
No, my lord. Upon submitting the second upfront amount, he will be declared as a successful bidder. Then the
Sir, the word is a preferred bidder.
Yes.
The word is a preferred bidder.
Preferred bidder
means the moment he has been declared as the highest bidder and deposits the amount, then.
My lord, if your lordship may kindly see sub-rule 3 of rule 10, it says the preferred bidder shall be considered to be the successful bidder upon A, continuing to be in compliance with all terms and conditions of eligibility, B, payment of the second installment of the upfront payment. This is a requirement under the statute.
That is unamended.
Yes, my lord, unamended.
So why don't you pay the second installment, sir?
Second installment they haven't paid. Third installment they haven't paid. Lease deed can only be executed upon submission of both.
So you have completed the public hearing. Let us take it in that way. Have you completed the public hearing?
Regarding that, my lord,
so
I'll have to file a counter affidavit and agitate because they have raised certain statutes.
Mr. Singh, I reserve my comment on this judgment. I am not making. But
please,
what does it mean and how it will apply and what was the ratio which is laid down there? I am not saying
just have a look at, on fact, just have a look at page 83. 83. These are the timelines. That is for the 20%, the second installment.
Only thing is, yes,
page 83, Lord, 83. Clause 16 is the first installment, which is called T1. Yes. In this case, I paid this on, just mark a note, Lord, 17 to 23, I paid that. Now, T2 is
17 to
23. 23.
Yes.
And LOI is issued on 27 to 23 within 10 days. Yes. Now, Lord, T2 is T1 plus 2.5 years. T1 plus 2.5 years. 1 year and 2 months before that, I asked them for a public hearing, which is to be done in 45 days. That is in June 24. This 2.5 years expires on Lord 26/8/25.
26?
8/25, 2.5 years. And I asked them for a public hearing in June of 24. Just see that document also. In fact, the Orissa Pollution Control Board asked them to have the public hearing. That document will find at page
128 initially.
128.
We want to hear this.
Orissa Public Service is asking them 1 year and 2 months ago, which is to be done in 45 days. They don't do it till date. And I am repeatedly asking that you have to, unless you do this, how do you expect me to pay the second installment? My second installment is not supposed to come immediately, Lord. It is to come after 2.5 years. And well before about year and 3 months before that, I have already completed the TOR, I have completed the mining plan. And after TOR, I have submitted the environmental application. That application is submitted to the Pollution Control Board and they ask for a public. Just see the 125 one, 128. One more document. No, 128, the Orissa Public Service Commission. Orissa 128, Lord, 128. (128) is the State Pollution Control Board, Odisha, writing to both the districts. There are 2 districts involved, Lord. Kalahandi, and the other letter is at 130, Raigada. They say that Kalinga has done everything. Please do the public hearing, which is to be done within 45 days. Till date, they have not done this public hearing.
Last paragraph.
So I keep
Last paragraph.
of this law. Yes, yes, Lord. It is further reiterated that conduct of public hearing is a time-bound program and date of public is notified through newspapers in 30 days. Under the above circumstances, I request you to suggest a date and time and with at least 40 days advance notice. Till date not done. And I repeatedly asked them.
The successful bidder, it is not the preferred bidder, but the successful bidder who upon submission of the third installment is to execute the lease deed. Then your lordship may kindly see the first proviso to rule 6. First proviso to rule 6. That is sub-rule 6 of rule 10. The first proviso your lordship may kindly see. Before that, I'll take your lordships to rule 4, sub-rule 4 of rule 10.
Yes.
That after somebody is declared, yet he is yet to be declared as successful bidder, but I am referring to the provision where, so far as the successful bidder is concerned, sub-rule 4, the successful bidder shall sign the MDPA with the state government upon obtaining all consent, approvals, permits, no objections, and as the like may be required under the applicable laws for commencement of the mining operations.
Yes.
Then 5. The successful bidder shall pay the third installment. It is the successful bidding of the upfront amount subsequent to the execution of the MDPA, and upon such payment of the state government shall grant the mining lease to the successful bidder.
Yes.
Then 6. The mining lease deed shall be executed by the state government within 30 days of the date of completion of the conditions specified in sub-rule 5, it is by the successful bidder, and shall be subject to the provisions of the Act and the rules made thereunder. Now the proviso, provided that no mining lease deed shall be executed on expiry of the period of 3 years from the date of letter of intent. The specific provision, and the letter of intent shall be invalidated, leading to annulment of the entire process of the auction.
And then second proviso.
So that 3 years period is yet to expire, and it is to expire on 26th of February. And
where is the provision relating to the public hearing? Public hearing.
Public hearing, that is under the EIA notification. That is one of the obligations for the environmental clearance.
So it has to be read in tandem with other. Because if that is what the it says letter of intent will not be issued unless the public hearing or something.
Nothing can be done because I won't get environmental clearance. Without environmental clearance, so unless environmental clearance is in place.
If there is some two laws operate in the same simultaneously in a same field, then one has to just make a the nexus in between that what is required. Can you do it without the public? Can you give a EC certificate without the public hearing?
No, without the EC. This is
I am just asking. Can you give an environmental EC without the public hearing?
EC is given by the impact.
Is from one hand, right hand to a left hand, and then saying that I do not know. They cannot join together.
Well, but see, look at the letter of intent that is at annex.
Sir, I just wonders that when you are deciding to auction a particular mines, are you not supposed to first obtain the clearance from the environmental department that whether it is conducive, it is good or not? If the environmental clearance does not, or environmental department does not say that it is good, then how can you go for an auction? I'm just asking a question. How can? Why there would be a separate thing? Whenever you decided to auction a particular mine, hold a public meeting, whether we can auction these mines, whether we'll go for that, we'll not go for that. If the public hearing says, no, it is not good for them, don't auction it. You can't sat over the money of the another person in this way.
The public hearing, not a condition under the
I'm still asking when letter of intent and all everything that you'll have to make a synchronization between these two provisions. If one overlaps the others, then what?
And the public hearing is to be held by the district magistrate, which is directly the state.
Is it a condition precedent for
Just see pages prior to environmental clearance. If your lordship have the same book at page 456. 456. Stages in prior environmental clearance process.
456.
Yes, Lord.
No, we don't get it.
Just give me the page number.
454.
Application for prior environmental clearance starts at 455 and stages not includes public consultation at stage 3. You would have done 1 and 2. 1 and 2 we have done. 1 and 2 we have done. Public consultation the district magistrate has to call for. And in the appraisal.
Next. Yeah, 42. Yeah.
You know how he impacts your the letter of intent or execution of a
I have
lease.
to get an environmental clearance to before the binding lease is to be signed.
Where do I get
show
it?
that is
Where do I get it?
Yes, I just show that. Page 98.
Is where?
Where is the binding EC approval specifically?
All confidence
just see plot page 98. Subclause B, signing of mineral mine development production agreement.
Yes.
Mudra Aluminium Limited shall sign the mine development.
No, that I have seen agreement. Upon obtaining the all consent, approval, permits and everything.
As may be required under applicable laws.
It's true.
For the institute of mining operation. EC is the requirement of applicable.
Signing off.
Yes, so this is the last stage. That's the lease deed, final lease, which is to be done within 3 years. So if I have done my bit as early as in June of.
What is the condition for deposit?
So far as the lease deed is concerned, it is to be executed by the successful bidder.
But that 3 years period is expiring.
But that 3 years period is expiring so far as preferred bidder is concerned. Your lordship may kindly appreciate the preferred bidder becomes a successful bidder upon depositing the second upfront amount.
Sir, that is I am asking a preferred bidder.
Yes.
Where?
Your lordship may kindly see rule 10 again. Rule 10 again. Rule 10 again, your lordship may kindly see. Sub-rule 1. The preferred bidder shall submit the first installment of the upfront payment as per rules 11 within 15 days after being declared as a preferred bidder.
Then I understand what you are.
Then I'll take your lordship to sub-rule 3. Sub-rule 3, your lordship may kindly appreciate. Sub-rule 3. The preferred bidder shall be considered to be the successful bidder upon.
Yes, I got your point. That is also there in page 97 at the bottom.
Then,
I have seen that.
For a moment. Then 4, your lordship may kindly see. The successful bidder will sign the MDPA with the state government upon obtaining all consents, approvals, permits, no objections. That is given to the successful bidder. Successful bidder will obtain all the consents and everything, and he will deposit the third upfront. Then the lease deed will be executed.
No, only second.
No.
Only second. Page 98, clause 2.
Yes. Upon submitting the second, he is yet to submit the second.
That's only, not third. He is supposed to only pay second.
Third, so far as execution of the lease deed.
That is what is given.
Upon declared as a successful bidder. He is yet to be declared as a successful bidder.
Deposit the second installment. Deposit the second installment.
One last thing, and I'll do. Just see page 83, 1 second.
No, I have seen that.
That second installment is to come in 26/8/25.
Whatever you deposit, we are saying that you deposit the second installment, and then we'll say there is no difficulty. Then he is a successful bidder as per this agreement itself clause. No difficulty.
But he is a preferred bidder. He will become a successful.
Deposit the second installment now.
Yes.
Will now do the. Yes.
No, the lordship will be 30 days, not consistent.
Fortnight.
Very good. Only difficulty is not that I understand the point that he's trying to argue. Successful bidder date was 26/8/25.
No.
That's one line.
That I have seen.
Only one line.
Yes.
26/8/25 is the day when I was to pay this amount. My representations to them are lying since June of 24. So that is why they did not ask me or declare me that I am.
We'll see to it that the period can be put into a moratorium.
Lord Secretary also said no coercive action.
That is what is there.
Item 13
Passover matches may come up.